So, let me introduce our principal discussants this evening, and we'll get right into it. We are here today primarily because of, can I hold up your book?
Yes, please.
This book, written by this person. Amy Werbel is Associate Professor of the History of Art at the Fashion Institute of Technology. She is the author of 3 books, including, most importantly for tonight's festivities, this one, Lust on Trial, Censorship, and the Rise of American Obscenity in the Age of Anthony Comstock. Just out, we are delighted to have her here to talk about it. Leading the discussion will be Nadine Strossen. Nadine is the John Marshall Harlan II Professor of the New York Law School, and as most of you know, she was president of the ACLU from 1991 to 2008. Her most recent book, which she does not have to hold up, is Hate, Why We Should Resist It with Free Speech, Not Censorship, which was published in May. Nadine and Floyd Abrams are to the First Amendment Salon what Steve Martin and Alec Baldwin are to Saturday Night Live.
Oh, are we that funny?
They are now tied. They are now tied for most appearances at a salon. so we are very grateful to Nadine for again stepping up to the plate and doing this. And with that, I will turn it over to you.
I'm so delighted to be here, Lee, and many thanks to you and your colleagues for your gracious hospitality, and it's delightful to be sharing the platform again with Amy, whose wonderful book I got to read early on when she gave me the great opportunity to provide a blurb for it. And in October, we had a really interesting discussion at the Fashion Institute of Technology about themes that united both of our books. But Amy, first I'd like you to say a bit more about what your academic background is, and because it seems a rather unusual background and expertise to have led you to write this book about Anthony Comstock.
Wow, okay, so the course of my career has definitely taken twists and turns, but there's been a consistent theme throughout, which is that I've been very interested in artists who got in trouble. And I started in college working on the artist Thomas Eakins, and Eakins was a Philadelphia painter, born and raised in Philadelphia, spent very little time outside of the city, except for 3 years in Paris. And he was introduced to a much more kind of worldly, cosmopolitan, open attitude towards the body. And when he came back to Philadelphia and tried to teach in the way that he had been taught in Paris, he was, fired from his job at the Pennsylvania Academy of Fine Arts. Many of his paintings of nudes were kept out of exhibitions. So he never was prosecuted himself, but he experienced a lot of censorship. And so my first book is Thomas Eakins' Art, Medicine, and Sexuality in 19th Century Philadelphia. And when I was thinking about another project following on that, I thought about this name that kept cropping up in my research, Anthony Comstock. And for an art historian, we didn't study Anthony Comstock at all, even being an Americanist for my entire career. And I just started to dig around a little bit and realized that nobody had written about Anthony Comstock's very profound impact on 19th century art. And so as I started to dig deeper and deeper, I realized there was definitely a great book project there. Along the way, I got interested in censorship really broadly. I was reading about the theory of censorship and different aspects of censorship, direct censorship, social censorship. Certainly there's a lot of theory about whether it actually, or the balance between the culture that suppresses and the new culture that's created through censorship. And so I went to China for a year on a Fulbright scholarship because I wanted to have the experience of living and teaching in a society that was, heavily censored, and that was really informative. And then I came back and finished Lust on Trial. And my work has always been interdisciplinary, and I know I'm in a room full of lawyers and legal historians, and I did my best to cover a lot of the scholarship really in your field and to use that to understand the experience of artists, the things that they worried about, the ways that they conformed to convention, and then also the ways that they challenged convention. And I know as we discussed before, I really became so impressed by the important symbiotic relationship between people in our society who produce culture and content, and then the legal system that frames that production and then actually changes in response to it as well. So I thought these were stories that needed to be told together, and that really hadn't been done that much in the scholarship before.
That's so interesting, and you remind me that I, and for many people in this room and in Washington, Anthony Comstock is a household name, but that may not be true for everybody. So if you, for better or for worse, if you were to give a fairly succinct explanation to somebody who hasn't heard of him, who was he and why should we still care about him today?
So Anthony Comstock was born in 1844 in New Canaan, Connecticut, and he was raised in a very devout evangelical Christian family in the Congregational Church, and that's very important to the course of his life and career. He, from a very early age, was really obsessed with the materials that produced sexual arousal. He felt that they would lead individuals to hell, basically. His conviction was that if he could rid the United States of sexually themed materials, including everything from sexually explicit photographs to birth control, to sex toys, to sexual health information, to explicit illustrations of reproductive anatomy and medical textbooks, if he could get rid of all of that, then he could reduce the lust that led people to sin and then led them to the damnation. And as part of his evangelical mission, that was how he decided to save souls. And he started out in his hometown as a teenager, trying to get saloons to close down, because alcohol, of course, is wrapped up in all of this. I served in the Civil War briefly, and then his active career began in New York City in 1872. He's conducting vigilante raids. He's working as a clerk in New York City, trying to get the police to round up pornographers. And then he has this lucky moment where he kind of collides with the gentleman of the Young Men's Christian Association, New York City branch. And they've been very concerned with the abundant pornographic materials available in the city and their effects on young men. And so now we have Anthony Comstock, who really didn't have any resources other than his fierce conviction and his energy, coming together with men who are very powerful. They have powerful political connections and they're rich.
And at this point, what was the legal landscape? Was the abundance of material because there were no laws that made it illegal, or the laws weren't being enforced?
The laws, such as they were, came from English common law. So when the colonies became states, they pretty much continued using the English common law they had used when they were colonies. And there is a sprinkling of cases that we know about through the 19th century, a handful here and there of people being prosecuted for the crime of obscenity. The way that was framed in English law went back to the roots of the concept of blasphemy, and also obscene libel, which was kind of thought of as disrupting the common good. And because the king or queen was the head of church and state, and this is really important for the First Amendment aspects of my project, it's really important to understand that before Comstock's era, political speech and sexual speech in the English tradition are both prosecuted in the same way, because it's an offense against the head of church and state, right? There's no wall of separation. So what's called, blasphemy and obscene libel, these cases are prosecuted in the same way, and it could be that you are an atheist saying that you don't believe the New Testament, that is blasphemy, which could be called obscene libel, or it could also be what we would think of as seditious speech. So those were kind of wed together in the English tradition, but America in general was a very libertarian place, and I'm looking at Stephen Solomon and flowing from his book Revolutionary Descent. It was a nation that was born in protest. And that kind of small government ideology really held sway. And the effort, the abolitionist effort, galvanizes these Congregationalist evangelicals to think that maybe government should be involved in making America a more moral nation.
You just used the word abolitionist in a way that gave me pause.
Well, no, literally the New England kind of abolitionist movement kind of politicized members of these Congregationalist churches in ways that after the war carried into the energy towards moral reform efforts. So the landscape is that there was some prosecution, and the effect of what the prosecution that there was, for example, in municipal or state cases in New York, was that people started using the mail a lot and catalogs. So you could get a circular, and then you could order through the mail sex toys, condoms, smutty pictures and books. So rather than being sold in storefronts, it's going through the U.S. mail, and that's going to set the stage for what Comstock really tries to do, which is to write an amendment to the postal code. So the landscape was that there was a lot of material imported. As tariff acts were put in place, there was more domestic production. As New York City was kind of clamped down on a little bit, it spreads and diversifies to other parts of the country. And mostly at the beginning of Comstock's story, he has real difficulty in New York getting anybody convicted.
Before we go more into the fascinating history, Amy, to put it in perspective for people who might not know very much about him, I kind of want the headline of why should we care?
Yes,
what
why
is
should we
his
care?
lasting impact, if any?
I think Comstock is the most successful example of efforts to make America a Christian nation through force of legislation and prosecution. And the outcome of that campaign should really give all of us pause in many ways, not only to think about the damaging effect of the intended effort, but also the very complex unintended consequences that his campaign to make us a moral nation produced. So I think there's a lot of kind of cautionary tales for the modern era, and I always think if something sounds like, oh yeah, Comstock would have said that, or Comstock would have liked that, the red flags should go up. So the more we know about his story, I think the more we can really embrace our free speech tradition, understand where it came from, and really understand when it goes off the rails, how damaging that is to civil liberties, to pluralism, and in particular to women.
Great. So now that we understand the important lessons to be derived, why don't you pick up the story about how he gained power, and I guess if you could intersperse with that efforts to check that power, and why some succeeded and when they succeeded, and what lessons, constructive lessons, can we learn to prevent somebody like that from accruing power again?
That's an interesting way to put it. I think thinking about what was
sorry, that's
easiest,
the activist in me.
No, what was easiest and hard, it was easiest for them to pass law because they had all of this network of Christian evangelicals in every level of government, and including Supreme Court Justice William Strong, who came from Connecticut and was president of the National Reform Association, and their big mission was to amend the Constitution to specifically state that Jesus was the ultimate sovereign of the United States. He's trying to make that happen while he's a justice on the Supreme Court. And was so these YMCA members of the Committee to Suppress Obscene Literature.
We think we have problems with the Supreme Court.
Yes, exactly. They included people like Samuel Colgate, Morris Jessup, very wealthy Christian industrialists. They're all from Connecticut. They all came from this Congregationalist evangelical background, and they it was really not that hard for them to draft legislation that outlawed pretty much anything. There was some legislation already in New York State. In particular, they passed a law that expanded the things that could be deemed to be obscene, right? And then the federal law, which they got passed in the winter of 1872 to 1873, made just this huge long list of things, of even like papers. So now newspapers advertising sexually themed materials for the first time could be suppressed. Birth control, abortifacients, all become illegal in federal law for the first time.
And this is the so-called Comstock Law.
It's called the Comstock Law, but really it's important that it was an amendment to the Postal Code, because the federal government only has jurisdiction over the U.S. Postal Service, Washington, D.C., and territories. Mm-hmm. But then that literature passed really quickly, and then the language of that bill was passed in state legislatures.
Excuse me, somebody in Washington, we can hear you. Sorry, we're not trying to censor you, but we're trying to hear Amy. Do you mind starting that sentence again?
Yeah, so the Comstock Act, which again was an amendment to the Postal Code, was really important because then that language was passed in different state capitals. And Comstock had a way of doing this. So in 1872, he went to Congress with suitcases of pornography, famously dildos, which they're all talking about. They can't figure out like what they're for. Literally, this is the conversation that they're having in the vice president's office, where these things are spread out on the table. And the congressmen and the senators are coming through to look at all this, and oh, it's horrible, it's terrible, and then they go and pass this law, no problem. And then that language is passed I think by 1900, there's like 40 different states have this law that now this is a state crime. The problem is that Comstock comes back to New York City, and now he's got his legislation, but the police could care less. They're all on the take. So when he tries to shut down performances in brothels, for example, or tries to have a kid selling a basket of explicit photographs on the street, thrown in jail, he just sees them going out the back end. And so now they realize, well, they're going to have to actually change culture in order to enforce this law. And I think that's one of the first important lessons. Thinking that, okay, you wrote the law, now we're done. Well, not so fast, not in America. Because you have to have a legal culture that kind of supports deeming what you think to be a crime is actually a crime. And a lot of judges and juries were just like, I'm sorry, this is not important at all to me. And so in the early period, like the first 5 years, they're getting almost no convictions, and they're very frustrated. And then they make a very big breakthrough in 1878, and this is in the prosecution of freethinkers and free love advocates, and these are blasphemers. Comstock writes in his arrest blotters, he calls them infidels. That's their religion in his column for noting the religion of the defendant, infidels. And he uses the term free lusters instead of free. And he actually wins this on appeal in New York State, a conviction against an old man, D.M. Bennett, for selling a copy of Ezra Heywood's book, Cupid's Yokes, which was an anti-marriage diatribe, basically talking about how marriage was terrible for women because they lost basically all of their legal rights within marriage. And they lost, for example, the freedom to say no to their husband if they were sick or if sexual relations were painful. Or and so this is a very explicit screed, and this old man got sent to jail. And the test that the court used in that moment was the Hicklin Test, which also came from English law. And that basically said that anything that was deemed to deprave a person whose mind was open to immorality, that became the new standard for obscenity. And after that test, the Hicklin Test is upheld on appeal in New York, then Comstock starts to get a lot of convictions because it's so broad. anyone who would be open to immoral influences. So that could be a child, that could be, and this was really the rub, working class people, immigrants. So these sort of class distinctions get woven into how obscenity laws are enforced. So if a gentleman's library has, Boccaccio, lusty stories, that's okay. But if that material is sold in cheaper paperback version, then that would be condemned as obscene.
To ask a naive question, the juries were not a cross-section of society? Or were these cases mostly before judges?
I think the really important thing about the juries in this early phase is they were never shown the evidence. Because Comstock basically said it would be harmful to the jury. And the judge in these early cases accepted that. And so the only thing the jury was ruling on was basically, do we have evidence that this person handed over this document or advertised this product, or was the person who, produced, distributed, sold said object that they didn't get to see.
And to be, so we can make some kind of more contemporary comparison, am I right that the harm was specifically that the condemnation of their souls?
Exactly.
Yep.
Comstock said that things that were seen once could never be forgotten, and they existed in a chamber of sin within the heart. So if you had improper arousal once from seeing a bad image or reading a bad story, that you could never get that out of this chamber of sin. So you were likely to die in hell, even just from one brush with obscenity. So I think the really important thing here, and it's one of the reasons I spend a lot of time thinking through his upbringing, is that what he and his Connecticut evangelical brethren bring into the American legal system is a very particular theological view of the body, of lust, of sexuality, and they're basically attempting to enforce this code of ethics that derives from that very particular theological view. And I think that is clearly still with us today.
And so basically there was a cultural change from a more libertarian attitude to a more repressive anti-sex attitude?
Well, I think that even at the beginning of the resistance, let's say, which starts really around 1878, when these free thinkers are targeted, Robert Ingersoll, who's a great attorney and sort of America's most famous agnostic, his thing, he's not a free thinker. He says, well, if you can prove the New Testament to me, I'll believe it. I just want some scientific evidence. So that's the difference he establishes between agnosticism and atheism. But he gets involved in the defense of these free thinkers, and at the beginning, they want nothing to do with obscenity. And I think that's a really interesting part of the story, that even though these, free thought publications are being prosecuted as obscenity, they make a big distinction between that kind of intellectual matter versus sexually explicit photographs. So the early defense attorneys who get involved in pushing back against Comstock, they don't want anything to do with the basement dwelling pornographers of the Lower East Side. And then that's going to obviously be a big part of the story of First Amendment law as it evolves in the 20th century. And that edge really, that distinction by the time of Comstock's death in 1915, part of the story I tell in my book is the way that wall of separation really starts to erode between primarily sexual speech and primarily political speech. And maybe we can get to that later. But just to move on, so Comstock starts to get prosecutions of a lot of things in the mid-1880s after the Hicklin decision. And then he kind of becomes a victim of his own success, because then he starts to get convictions for things where get splashed across the newspaper that everyone is shaking their head saying, really? Those paintings and those famous French paintings have now been ruled to be obscene. So then it becomes more of a the slippery slope problem really starts to undermine his authority. And that's where I think artists are very important, and art dealers and art collectors, because they're the ones who start to say, who is this guy, Anthony Comstock, and why does anybody take his assessment of art seriously? And defense attorneys start to say to him, have you ever been to a museum? Have you ever traveled in Europe? You know, have you ever actually studied art or made art? And the issue of expertise, which is not at all a part of this first decade of cases, then you see the defense attorneys insist that judges be able to see the actual evidence and that expert witnesses actually be able to comment on the material. This all happens in the context of art.
But in the, you know, to just flesh out, no pun intended, what the legal test was at the time, I assume there wasn't what we now have, that something will be absolved of or will not be considered unprotected, constitutionally unprotected obscenity if it has serious literary, artistic, political, or scientific value. I assume that wasn't a prerequisite for conviction under the Hicklin Test. So how was it relevant, whether it was considered art or not?
I think what fascinated me so much, because when I would pick up the normal, you know, legal history textbooks about First Amendment law, you usually jump from the Alien and Sedition Act to the Espionage Act. So you basically leapfrog over all of this history, you know. And what really fascinated me was the way, before any of these court decisions are happening, the concepts are happening. Because contemporary community standards, that's what they're talking about in these court cases, where the defense attorneys are saying, well, how can you say this is illegal? I just went to the theater last week and saw the same exact thing. And if you're going to say that this is obscene, then you're going to have to rule that every other, you know, burlesque sketch on in the theater right now is obscene. So, you know, the concept of contemporary community standards evolves during this period of time as defense attorneys do what they do, which is to find arguments to defend their clients, and procedural issues like Comstock used to burn the evidence before the trial because it's just the sooner it could get into the incinerator, the better. He would save a little bit of it so that he could take it on his road shows. He'd always have suitcases of porn ready to show to people men in power. But then the judges start to say, no, you know. We're going to establish that you may not destroy the evidence until after the trial. That becomes a thing. And then increasingly, by the time Comstock dies, judges are saying the jury has to be able to see all the evidence in the case, because how can someone be evaluated by a jury of their peers if their peers actually cannot evaluate the substance of their supposed crime? That's a thing. Comstock is told he cannot open mail. That, you know, because the search and seizure issues, he had just been like, if he would go into someone's production studio and had mail ready to go, he'd open it up, and then the defense attorneys are pushing back on that. So I think that the issue about establishing what is obscenity is that as much as they try to make a standard, it's the same thing. It's like, who gets to decide how the test is actually administered or viewed. And when it's just Comstock, then there isn't that conversation happening in the courtroom about where is the bright line right now. And as these cases evolve, and Comstock is really creating a First Amendment bar by bringing so many cases to court, that there start to be a group of lawyers who are, you know, developing expertise in this area of law. And
can you tell us a little bit about them?
Yeah, well, they're an interesting bunch. I spoke to the New York City Bar Association Legal History Committee a few weeks ago, and I was talking about Comstock's first kind of splash in the newspapers is when he prosecutes Victoria Woodhull, who was the first woman to run for president on her own platform, and the first, you know, woman to have a seat on the New York Stock Exchange. She's quite a character in American history. And she published a newspaper with her sister, Woodhull and Claflin's Weekly, and they wrote this very scandalous newspaper article about Henry Ward Beecher having sex with his parishioners on a little red lounge, and this is in Plymouth Church in Brooklyn Heights, which is still there and quite beautiful. And Comstock, you know, in the course of prosecuting her, I mentioned, he went up against these lawyers who I thought were hysterical, and I didn't know it was Howe and Hummel. Some of you may have heard of them, but these New York legal history buffs were all, Howe and Hummel, and they started telling stories about Howe and Hummel. They pioneered the breach of contract scam, which was that a prostitute would have relations with a wealthy man, and then Howe and Hummel would send a notice that they were going to be sued for breach of contract because the young woman had been promised marriage and wasn't being given marriage, and if the wealthy man would pay up $5,000 or $10,000, depending on how deep the pockets were, then they would not bring the lawsuit. So they were total scam artists, but they mounted this brilliant defense of Victoria Woodhull and got her up. But they were basically using that slippery slope defense. Like, this story is no more scandalous than Boccaccio. All of Greek mythology would have to become illegal if you said that this was illegal. So we go from there to Robert Ingersoll, the great orator, who found the first kind of organization, the National Liberal League, in 1878, specifically bringing together attorneys to talk about how to defend these free thinkers. And then the next organization is the National Defense Association in 1878. And that brings together mostly publishers of a variety of types of magazines and literatures of somewhat radical ideas. And they start to, pay for attorneys to defend Comstock's targets. People like E.B. Foote, who does, he's sort of kind of a borderline quack physician. But a lot of these people are writing about sexual health. And Comstock, anything that would have what Angela Heywood called penis literature. So if it had, she believed that it was important to use names for things, vagina, penis, and that if you didn't educate people about their bodies, then they would never kind of have a healthy relationship with sex and reproduction, and I'm using healthy in a really holistic way. So, but Comstock, anything with those words was Comstock considered to be obscene, because it was, arousing just to see that word on paper, according to him. So,
were members of the medical profession involved in these trials at all?
Yeah, I mean, the medical profession at that time is just about as kind of squishy as the legal profession, in terms of there are people who are, trained scientific doctors, and then there are people who are operating more on the margins of certainly nothing we would consider to be scientific, talking about, electrical, magnetic fields and all that kind of thing. I guess you can still find that today, but not mainstream medicine. And but definitely there were, in fact, in the course of my research, I was looking at Gray's Anatomy, and because, illustrations of reproductive anatomy were considered to be obscene and kept from the U.S. mail, there's a period of time where Gray's Anatomy has no illustration of reproductive anatomy. And this was sort of the, encyclopedia of body parts. But there's no penises and vaginas for a period of 5 years, when they were really kind of worried about it. And it was after 1878 when D.M. Bennett went to hard labor, he was condemned to hard labor, this man in his 70s, for 2 years for circulating Cupid's yokes. So that it's always a kind of a push and pull between, as Comstock gets more powerful, the pushback gets more powerful in response. And certainly we're living through that now, right? That Americans don't like their civil liberties being taken away, and they tend to send more money to organizations like the National Defense Association, which kind of becomes the Free Speech League in 1902, where some of the people carry over into the Free Speech League, and then that really is the, almost direct forerunner of the New York Civil Liberties Union, which becomes the American Civil Liberties Union. So you can really see that part of that totally unintended consequence of what Comstock was doing, which he was totally blind to, which he was causing all these people who really didn't agree with each other about anything. But they all wanted to publish their radical ideas. So you have people joining forces together at the end of Comstock's career. Margaret Sanger and Emma Goldman have a lot of arguments, But when William Sanger's is in jail, Emma Goldman's raising money for him, and when Emma Goldman's in jail, Margaret Sanger's out raising money for her, and because that cause of free speech unites all of them. It makes for some very strange bedfellows.
Did it extend to political dissidents and critics as well on issues other than sexual issues? I mean, the Free Speech League sounds very broad, but was it in fact focused on this specific important corner of free speech?
I think that one of the things, at one point I had this big flow chart of all the different radicals, because they're the union labor organizers. I mean, Clarence Darrow, who's very important to the Free Speech League and to the New York Civil Liberties Union, obviously he's very important to the history of free speech. But in 1894, he's defending Eugene Debs at the time of the Pullman Railroad strike, and Ida Craddock, who is an advocate of this sort of yoga sex thing, where she's talking about taboo time, and she's a fan of belly dancing, and that's the same year, and he's losing everything. I mean, he loses all of these cases. But I think what I see around that time is where the expertise that these attorneys have, even though there wasn't some intentional moment where they say, hey, you know what, we should defend both the political speech and the sexual speech. It just kind of happens because it's all, the same kinds of arguments and the same very nascent conceptualization of the First Amendment as being foundational to everyone's rights. Of course, the First Amendment will not technically extend to state cases until 1925, but people start really talking about just civil liberties of the citizen is what the phrase that they use the most. That this action, whether it is suppressing union organizing literature, anarchist literature, socialist literature, reproductive health information, and people sign on to different of these kind of radical agendas. So you can see in any one of the people that's being prosecuted, sometimes they'll agree with this but not that. So
free speech supporters should treat Anthony Comstock as a hero because he helped galvanize the movement and the law.
I think ultimately he was so unable to see the big picture of what was happening that became true. And the person who followed him, he died in 1915, the person who took over, John Saxton Sumner, was much more savvy. And he started trying to stay out of the newspapers and have the censorship happen behind the scenes. So, he's not any more effective, but by that time, by 1915, the ball is already rolling, and you have these very sophisticated defense attorneys, and you really and they are bringing the First Amendment question to the table. I mean,
and your book is dedicated for the defense. Are you referring to the defense attorneys or the artists or all of the above?
Yeah, I think I am, because I think it's hard, and it took a lot of courage for attorneys to represent very disreputable clients, and it took a lot of courage for people to challenge unjust laws when there was real risk to themselves, and in many cases people went to jail very unfairly, and they fought it, and they believed that being an American citizen meant that they had First, Fourth, and Fifth Amendment rights, and whether or not they articulated those particular amendments, or whether they used the same language we would use now, the concepts that they were evoking were really the same. And the more that Comstock succeeded, the more he really sowed the seeds of the demise of his project. And not to say that in 1915 things were rosy, they were not by any stretch of the imagination, but you start to see the concepts developing. We're not that far away from marketplace of ideas, right? And I think that what Comstock made very evident that we should really be mindful of today is what does what does democracy require? And you have people as eloquent as Walt Whitman and Mark Twain pushing back on Comstockery and saying this is not, who we are as a pluralistic country and as a dynamic, vibrant society that includes people of many different faiths and many different ideologies. Censorship does not kind of conform to the principles the nation was founded on. And so all of that literature, especially Walt Whitman, is really looked at by the generations of, judges and lawyers and defendants who are going to follow, in the 20th century.
Well, speaking of courage, Amy, I know that you made some courageous decisions in terms of illustrations for your book, and can you tell us about some, maybe show us some of them and discuss your thought process?
That was really interesting because I did have, the way I researched the book was I had the arrest blotters, which are in the Library of Congress, and I photographed them, and Comstock was meticulous. He literally weighed everything he burned and wrote about it extensively. And so then I set out to find the stuff because I am at my core an art historian, so I wanted to see the content and see what had been suppressed and unearth it so that we could have a fuller picture of American culture and society. And so I found a lot of the stuff. And interestingly, I sort of thought, it's going to be fun to publish this obscenity, things deemed to be obscene before 1915 and see how people respond now. Like where's our bright line now? And as it turned out, there actually was a bright line because the printer refused to publish 2 of the photographs.
Oh.
And so I was given a choice by the editors at Columbia University Press that if I insisted on keeping those pictures, those photographs, they would have to go with a printer that was going to charge twice as much, so the book would have been $60. Or I could leave out those 2, and these were photographs of individuals engaged in penetrative sexual acts. Okay, so like the real deal. And I really thought again about what does self-censorship mean? Self-censorship. I could call that self-censorship, right? Because I obviously chose not to put them in the book. But part of it is gauging audiences. And that's where censorship becomes the term, maybe a lot of people think they know what it means. But it actually embraces a lot of different kinds of forces from a lot of different kinds of actors. In that moment, no one was telling me that I could not publish those things. But there's an economic reality. And these content producers in the 19th century had the same kinds of choices. They could go so far, or they could risk liability, or they could risk not being able to appeal to audiences that included women, so a lot of it is about who's the audience for your work. And so I decided, well, $35, I would get a much broader audience, which I was aiming to share the story of American censorship and free speech with a broader audience. But if anybody wants the pictures, email me and I'll send them through the mail. It'll be fine.
I mean, was there concern that it would be criminally prosecutable as obscenity today? No, not at all.
That never came up. It was really just that particular printer. Well, that particular printer was worried that some of their other customers would be upset if they published those images. And this is where the social aspects of censorship, I think, are really powerful, and we don't tend to think about them enough, because when material goes underground, and I thought about that, so Comstock made the public sphere a much more difficult place to share sexually themed materials, so then it goes to private spaces where you don't get that social shaming effect, which actually, so this is where my subtitle, Censorship and the Rise of American Obscenity, the way that censorship actually made America more obscene. One of the ways is that when speech gets pushed to the periphery, to more hidden spaces, it doesn't have those social aspects of being contained by pushback that, that doesn't seem right to me, or, that joke's really a bit off, or, it's not getting that kind of constraining by normal measures. So in this case, the economics of it, if I had made a book, right now, in the 19th century, if I had published really obscene materials and they were more expensive, it might have been fine. But given that people can get anything they want for free on the internet, it's not like I'm going to compete and it's like, hey, buy my book and you'll see some pictures that, really juicy pictures, it's also like the marketplace of ideas exists within a marketplace of literally economic marketplace. And so that is a major, I thought this whole thing, I wanted to see where we are right now, and I think I really got an interesting, again, reminder that there's law, but no one was ever talking about law. We were talking about money, and we were an audience, and those things are really important to the shape of speech and the content of speech.
I think we're almost at the point where I want to turn it over to the audience, but at the end of your book, or toward the end of your book, you talk about these two institutions that had collaborated and had such a significant role thanks to Comstock, the YMCA and the National Society for the Suppression of Vice. And you make a comparison contrast in terms of their fates. Why don't you tell us a bit about that?
Yeah, and actually I can't believe I haven't said New York Society for the Suppression of Vice. So what happened, and this is great to go back to this moment in 1874, Comstock is the conquering hero. He comes back from Washington. The Comstock Law has been passed. That language is passed in the New York State Legislature. And the YMCA, the Board of Trustees says, we don't really want to be associated with your work anymore. They had just built this palace of recreation on 23rd Street. They had gyms, they had lectures, you could see slideshows of travels in Europe and lots of Bible study. And that's what they wanted to do, and they felt like as these prosecutorial efforts started getting into the newspaper, they just said, this isn't our mission. We want to encourage young men to choose virtue, and we want to provide them with lots of healthy activities, healthy recreation, and we're just not comfortable with this. And so this committee for obscene literature left the YMCA and incorporated in New York State as the New York Society for the Suppression of Vice. So Comstock, from that time, his authority stems from being secretary of the New York Society for the Suppression of Vice and an inspector for the U.S. Postal Service. So he has the New York Society for the Suppression of Vice, in the Act of Incorporation, says that the police are required to make indictments on their behalf, which becomes a source of a lot of tension going forward, because the police never want to deal with this private moral reform society, which seems to be very, inappropriate, to say the least. So that moment, when I think back to that moment in the conclusion of my book, it just struck me that that's the really big takeaway. So you want to make American speech better. You want to make America a more moral society. We have this example of the choice of the carrots, and how many of you have heard of the YMCA globally? And then you have this choice of going the route of sticks and prosecution and litigation and censorship. And how many of you have heard of the New York Society for the Suppression of Vice, right? The historical example shows that if you want to have sustainable effect, positive effect on American society, choose to fund education, choose to fund, entertainments and ideas and books and literature that support and make the case for your ideology, appeal to people in a positive, affirming way. Because going the other route just ends up with more unintended consequences, because we are at our core a nation founded on libertarian principles, civil libertarian principles, and I don't see that going away anytime soon. So that is kind of the big take-home lesson of Lust on Trial.
Wonderful, wonderful lesson. Thank you so much. So, questions, comments? We've got wonderful folks around both tables with a lot of relevant expertise on various aspects. And I'll just call on you in the order in which I see you, starting with George and then Lee on this side. Or should I alternate between New York and Washington? Okay. Okay, so I see George, Ron, Lee, anybody else? And I'm sorry, in the back? Gail. Okay, and Mark, okay, for starters. Hi, okay, Ashley. Great. I'm sure we'll have time for more than that.
Okay.
Amy. I'm sorry, George, you're first.
So I'm just curious.
Could you mind introducing yourself so everybody can know who you are?
George Freeman, I'm the director of the MLRC. You know, for the most part, I think we can agree that sex is a good thing, and that generally speaking, it doesn't cause too much pain and suffering. On the other hand, violence, we can generally agree is a bad thing.
Right.
It leads to pain, suffering, grievous injuries, and death. So why is it that there were all these attempts throughout our history to censor sex and obscenity, and as far as I know, almost no attempts to censor something that results in much worse results, which is to say violence?
Oh, I completely agree with you. And again, it goes back to this very particular evangelical obsession with sexuality that derives from a reading of the Old Testament, that when Adam and Eve, the first thing that happens when, Eve gives Adam the apple, right, and they bite it, and the first thing they do is they realize their nakedness, and they fashion fig leaves and cover themselves with an apron. And so that really became the basis for seeing sexuality as shameful and as a part of the fall of man. Sexuality is at the root of the fall of man. And so that, again, that's where I really want to point out is that obsession in American law derives from the English theocratic mingling of, blasphemy against the church and sedition against the king or queen, all being considered the same type of, legally culpable behavior. So hopefully that answers or begins to answer your question.
Ron.
Amy, it's so good to have you.
Introduce yourself, please.
Oh, I'm sorry. I'm Ron Collins.
Hi, Ron.
And it's so wonderful to have you. And as someone who's read your book, even before it was written, or published, I should say, actually, because we saw the article.
Yeah.
You wrote an article that I saw early on.
Yes.
It's just wonderful, and I'm delighted to have you here. I was thinking about a question that Nadine raised about Comstock's relevance today, and something occurred to me, and I'd like to put this out as a suggested course of action if anybody besides me is interested in it. One of the things that all First Amendment casebooks, and I mentioned all First Amendment casebooks used in law schools have in common. The modern First Amendment begins in 1919 with political speech.
Right.
Yeah.
It is just something has to be done. I mean,
Here.
the Alien Sedition Acts of 1918 and 1919 are seen as turning points in free speech history, and nobody's talking about what happens in 1873. Nobody's talking about the Free Speech League. Nobody's talking about Theodore Schroeder, et cetera, et cetera, et cetera. And so here's the proposal. If other people are interested, I'm certainly willing to aid and abet however I can. What about a letter written to Erwin Chemerinsky, Steve Schiffer, and Eugene Volokh, et cetera, et cetera, et cetera, putting together a 2 or 3 page memorandum as to that they should change their casebooks or alter them or modify them so the modern First Amendment doesn't begin in 1919 with political speech, but it begins much earlier with sexual expression. And I think one of the reasons that political speech is on such a high pedestal is precisely because of this. We don't think of the suppression that took place before 1919, before Schenck, Abrams, Frohwer, you know, and so there's just a suggestion, if anybody else wants to aid and abet in drafting such a letter or memorandum, I'd be happy to do what I can to facilitate it. And I think your book points to the need for just that sort of thing.
Thanks,
Can I
Ron.
add that this, Amy, hi.
Hi.
My name's Robin Mugner, and I run the Center for Inquiry. And
Oh.
we actually manage and own the birthplace of Robert Greene Ingersoll.
Yay.
In New York. And the organization has a long attachment to the free thought movement in the United States. And so I hope that actually the review that you're talking about, Ron, goes back to English common law
Yeah.
and starts with this theocratic line that you were mentioning and the connection between blasphemy
Yeah.
and restrictions on blasphemy, and then later having it morph more into the sexual realm. Because as you say, and it was brilliant point and it's so important, it gets completely lost in First Amendment law. That is the derivation
Yeah.
of the fight against it.
Yeah, and I really think one of the things that I was trying to tease out in my book is where does an American concept of free speech begin to depart from this reliance on English common law? Because all of the decisions, I mean, the Rex v. Curl is used in American law. It's an English decision from 1727. And then the Hicklin Test, which again is an English decision. And just as, again, being a history of art professor, I kept saying to, well, my husband Fred is a legal historian as well. And I just kept saying, why do they keep talking about English law? I don't get it. They're American judges and they're in American courtrooms. And so that's where it really, I think, struck me as being so strange and incongruous. And I had to really go back and dig very deep to find that. And actually, the next project that I'm working on is a comparative study of art censorship in the United Kingdom and the United States in this period of time. When there's a lot of back and forth across the Atlantic, there's a lot of discussion of Comstock in London, and there's obviously a lot of discussion in the United States of these English decisions. So I think it's interesting when this divorce begins and how long it takes after we become our own nation with our own very distinctive legal framework for speech in the written law, but not in the culture.
Ron, I nominate you, since you're such a fast and brilliant
Yes.
writer, to just write that new section of the casebook. Lee.
So this is obviously a product of the fact that I went to law school and used casebooks that did not cover this period at all. So you've got to help me with a kind of fundamental question.
Yes.
Which I probably should know the answer to, but I don't. What public office did Anthony Comstock hold that gave him the ability to do these kind of, like, lead raids and searches
Right.
and prosecute people? And
Destroy evidence.
Thank you. And it's a really great question and a really great cautionary tale, because when the Comstock Act, this amendment to the Postal Code, was written, this was the first time there was an enforcement provision in federal law. There had been anti-obscenity laws in 1842 and then in 1868, because there was a lot of porn circulating in the Union troops, and so they passed a law, but there was no enforcement provision. But the enforcement provision in the Comstock Act directed the postal inspectors to bring prosecutions against anybody circulating obscene material through the U.S. mails. So, and Comstock was given the commission as a postal inspector for the post office department. So, for example, when he went to get Victoria Woodhull and bring her to jail, where she sat in the Tombs for months, he brought a federal marshal with him, and the federal marshal was the one who made the arrest. So that's an example of when he has his postal inspector hat on. Wonderfully, he had to write reports back to Washington, D.C., and I use these are in the National Archives, which had never been looked at before. His reports back to the postal inspector, which I quote from extensively, some of which have evidence that he had rounded up, and he's showing the chief inspector in Washington what he's been able to do. So under state law, when the New York Society for the Suppression of Vice was incorporated, as I mentioned, there's a provision that says that all law enforcement officials are required to assist the New York Society for the Suppression of Vice in carrying out its stated mission. So when he wanted to arrest someone for, let's say, selling sexually explicit photographs on the street, he would bring a police officer with him who would make the arrest. And often, actually in the early cases, often the witness is a newspaper reporter. He would get a reporter to come with the police officer so that it could get into the newspapers as soon as possible. So that's really the act of incorporation, I think, is very unusual. Also, the Society for the Suppression of Vice got half of the fines that were assessed. So if you had to pay a $50 fine as your sentence, $25 of that went to the Society for the Suppression of Vice. So it's a very strange thing.
Wow. Gail? Is there a Gail? I wrote that name down. No, oh, that was Rob? Okay, so I thought I heard the name spoken. Is there anybody in DC who has a question? I'm trying to alternate. Bob?
Amy, Bob Cornelier.
Hi.
Terrific book. Congratulations.
Thank
it's
you.
really a wealth of information. I wanted to just pick up on the point that Ron made about the early First Amendment history. It seems like the only book that has gone into that as a legal matter is the First Amendment in its Forgotten Years, which is also, you know, a great book. But to pick up on the point that George made about how why is it only sex that's censored and not violence and other things like that, Anthony Comstock was an equal opportunity censor. He didn't just stop with sex. I mean, his Puritan religion drove him to be really paranoid about sex, but he went after everything. He went after medical textbooks, he went after art, and he went after dime novels. He was one of the first people to have crusades against dime novels for the very same reasons that Frederick Worden went after comic books, and you had the anti-TV violence measures as well.
Yeah.
And so all of that development in the 1870s through 1915, when he was active, were precursors for all of the culture wars that we have today.
Yes, absolutely. And also lotteries and gambling. You're right that there's a lot there. And one of the real challenges, as you know, of writing about Comstock is he doesn't seem to have slept for his active years. I mean, the number of defendants and, you know, the blotters, these arrest blotters, are just like massive tomes. So I really, because of my background as a art historian, I tried to focus more on the visual culture. And there have been some studies of, there's more writing. I mean, there's biographies of Victoria Woodhull, obviously Robert Ingersoll, and a lot of the other actors have been written about more. Susan Jacoby has written wonderfully about free thinkers, and so I tried to kind of add more to the picture of what hadn't already been discussed in the literature. So
Great. Mark?
Hi, Mark Wolko. I'm a second career law student and research assistant to Nadine, so very humbled to be in this conversation. Thank you very much. I look forward to reading the book, and I'm wondering, listening to this, I mean, I'm wondering where the missing part of the sort of unholy trinity of repression is. You've got the church, you've got the state. What were there economic, you know, not corporate at the time, but business, big business interests that were receiving any sort of benefits from Comstock's efforts? I'm sure that, you know, in some sense, businesses were producing these materials were maybe against it, but in the sense, were they waiting to fill the void? If he's suppressing materials, were they waiting to fill the void with something? Was there anyone there waiting to fill the void with acceptable, you know, not quite prurient, but stimulating material? You know, there's always, to me, there's always some sort of business economic forces behind this. Does that exist?
The range of culture, we should say, there were many people who really stayed away from anything prurient or, you know, possibly prurient. And so you have the American Tract Society churning out like tens of thousands of copies of Bibles and hymnals and that sort of thing. And so that's at one end of the spectrum. If you wanted to be pure, and, you know, that was no problem. Like, there was plenty of stuff. What happens at the margins, and one of the stories about how censorship causes American obscenity to rise, is that anything Comstock brings attention to becomes very chic. And especially, he was always overreaching. He was always going too far. So going after especially after the jury starts to be really allowed to weigh in, and there start to be expert witnesses in the mid-1880s, every time he overreaches, these trials are covered literally word for word in multiple newspaper outlets. Most of them are happening in New York, and they go out to the country through the telegraph wires. So if you're in Peoria, you're reading about the latest raid on a burlesque sketch on 14th Street. And in minute detail, they are writing about the tights that the actresses are wearing and the particular sketches that were found to be offensive. And so into that commercial opportunity spring Americans, as you can imagine, always, the bulls of Wall Street, Main Street, and 14th Street, who really capitalize on the chic modernity of all of this. And in fact, I make a point that there's an advertisement for this play that Comstock tried to have shut down, didn't get shut down, and people are advertising all across the country that the road company is the same road company that Anthony Comstock tried to prosecute in New York. They're basically like promising that this will be what he didn't like.
Banned in Boston.
Yeah, exactly. Oh, yeah, exactly. Yeah.
Great. Ashley.
So this kind of flows from what you were just talking about there. I was really interested in your point, and I love the coining of the term Comstockery.
Yeah.
Comstockery, creating a situation where you don't have the social pressure that would ordinarily be brought to bear and make things maybe a little bit less obscene, and how that relates. I mean, have you thought about parallels between kind of what happened here and what is happening?
Yeah, absolutely.
In foreign countries where, particularly repressive ones. Yeah. And what consequences could come from that? I mean, is the Comstockery that's happening in Arab countries, for example, creating the situation that happened here in America at that time?
That's a really interesting question. And one of the things I realized from living in China for a year, because initially I thought, I'm going to write a big book about censorship, and that the story of censorship would be the same everywhere. And that's really not true. And there's been a lot of discussion recently about, the Great Firewall. Everyone expected the Great Firewall to basically fail. Certainly when I was in China from 2011 to 2012, and it was still reform and opening, I left literally as Xi Jinping was sworn into office, and things became much more repressive. But the story of censorship has always been that the technology always wins, that the speech always moves. If you repress it here, it shows up there. That's an American story of censorship that you can take from Comstock's era to the present day. And I think I was just thinking about that recently with this horrible shooting in Pittsburgh. That man was publishing his anti-Semitic screeds on Gab because he'd been kicked off of Twitter. I'm just saying we really need to be aware of the fact that in American society, censorship tends not to destroy speech, but often to move it from one place to another and to move it from a public sphere to a less public sphere. And it's something that policymakers need to be really conscious of. But to get to your point, one of the things that I came to in my conclusion is, why is this different than Iran or China or now Turkey? And I realized, especially in the case of China, they don't have a narrative of successful revolutions. If you study Chinese history, every time there's been an uprising, millions of people died, and then another authoritarian regime came in. So as a historian, I was really taken by the power of our historical narrative, our creation myth. Creation myths are important for religions, they're important for nations. And again, I'm pointing to Stephen, because this is really what his book is about. So that's where I started to think that I needed to tell a very particularly American story. And some aspects of censorship are true everywhere, that if you look at all the different things that constrain speech or make speech possible, you can't just look at the letter of the law in prosecution. You need to look at social factors. You need to look at church and state issues. You need to look at money, price points. There's always, the profit margin goes up for obscenity, but so does the liability. But I do think that history matters, in addition to everything else we've already been thinking about.
Fascinating. Amy.
Oh, what a great presentation.
This is Amy Adler, professor at NYU.
Yes, and I actually I'm really intrigued by the comments about revising the First Amendment casebooks, because it seems to me that it contributes to this fiction that the First Amendment begins in reaction to World War
Right,
I
yes.
in a way that I think distorts First Amendment theory and maybe even case law by devaluing, by making political
Absolutely.
speech paradigm, the
Yeah.
paradigm of speech, devaluing artistic expression and
Yeah.
sexual expression.
Yeah.
And I mean, that's just a persistent problem. So I'm thinking of Justice Stevens and that famous line, few of us would march our sons or daughters off to war to see sexual activities of our, of our choice or whatever, that this low value speech doctrine of court and the low value accorded to sexual speech by jurists and theorists, and how different the world of First Amendment theory and jurisprudence might look if we actually had this history restored to the casebook. So I just
Wow, that's cool.
support for that too.
That's very cool.
Great idea.
And I actually think one of the things, again, when I was thinking about the chicken and egg thing, right, culture and law, that Emma Goldman and Margaret Sanger kind of, the sexual aspects of their speech and the political aspect of their speech, especially Emma Goldman, become kind of inseparable. Like sexual
Yes.
politics and gender politics and socialism and labor union organizing all get sort of, woven together, and certainly in a publication like The Masses, which I'm remembering your wonderful conference at NYU on The Masses, but all of that comes together in publications like that around that period of time. But really, you can go back to the free thinkers, and you can go back to the range of issues that somebody like Robert Ingersoll is, advocating on behalf of, and see that, sexual speech and political speech really were fused even in an earlier period, but maybe not in as, in as clear a way. But yeah, I would love for all of the First Amendment case law to be rethought. That would be awesome.
Fred. That's good.
Yeah, absolutely, yeah.
Fred?
Thank you, Nadine. My name is Fred Lane, and in the interest of full disclosure, I'm research assistant and husband to. I want to follow up on Amy Adler's comment, because I think one of the unintended results of omitting this chunk of history is that it supports implicitly the concept of the United States being a Christian nation without it actually proactively being spoken. And one of the ways that that plays out, and I think that this is part of the legacy piece that extends beyond the scope of Amy's book, is that one of the real key significances or resonances of Comstock work is that the language of the Comstock Act from 1873 has woven its way forward into legislation, including most recently 1996, the Communications
Exactly.
Decency Act. But it's incorporated into the Federal Communications Act of 1930, whatever. It's in the anti-phone sex language. It's sprinkled throughout American statutes. And I think because we don't talk about the fact that the First Amendment bar rose in response to this very Christian-based approach to speech, that we have defaulted that to be the status quo of American culture. And I would argue that at the very least you could spark a wonderful debate about how we should view that period of time if we move the origins of the First Amendment back 30 years.
Yeah, and I also think it's relevant, thinking about like Sesta Foster, which is really recent. Again, one of the lessons of this period of time is, it's easy to pass that legislation. Everybody wants to sign on to the legislation. It's much harder to actually change the conditions that people live in that give rise to sex trafficking. So it's easy to say, hey, let's just shut down the speech. But what Comstock managed to do, he didn't change American culture. I mean, he didn't change American culture. He hid the the underbelly of American culture. He forced it into darker spaces. But obviously, America, from the time he started his campaign to the time he ended, America was a vastly more obscene place.
Yeah. And this historical perspective is very much part of Jeff Stone's wonderful book,
Yeah.
Sex and the Constitution, and Amy did a couple great public interviews of him, where, you know, we all started with the assumption that it was the sexual revolution of the 60s that brought about libertarianism, but in fact, that was a much earlier part of American history, and the pendulum has swung back and forth. Did I see another hand over here? A couple hands. Okay. And I'm sorry, I don't know your name. Next to George, and then.
Okay. I'm Ken Sherry.
Oh, nice to meet you.
And my question is this: I mean, during the time, I guess, when Comstock was active in the city was run by Tammany Hall.
Yes.
And after public wrath, the second biggest financial support for Tammany Hall was the sex trade, and the protection paid by the sex trade that flowed into the police department.
Yep.
And ended up in City Hall. So, how did his campaign go down with that political structure in place?
It went very badly at first. I mean, he literally, they were plotting against him all the time. I mean, he's writing about this in letters and in the arrest blotter when he's writing about the actions the police are taking to smear him. For example, there's a really funny story. He raids a brothel that's right across the street from a precinct house. And the women literally hang out the windows soliciting. That's not his beat, because there's another moral reform society that does actual prostitution. That's Charles Parkhurst's society. But because they have a floor show called the Busy Fleas, where women perform sex acts on each other, and the clients, they would pay for a ticket to see the floor show, and then they'd get to pick a busy flea, which is really gross, to go upstairs with, right? But the police actually chronicled how long Comstock sat and watched the show. And they bring this up in court. So they're, right from the beginning, he is ruining their flow of payoff money, which is, I've been asked many times, well, weren't there laws in the books? And there were laws in the books, but they only basically functioned to make the blackmail possible. You know, that was how the cops got to get the money from the brothel owners. And often it included that the police officers, again, these brothels were near the police precincts. And so you start out in the 1870s, and the judge, that case is hysterical because none of the witnesses show up. Comstock has called all these witnesses, none of them show up, and the judge says, well, this case is obviously ridiculous, everybody go. And nothing happened, and I compare that with his last brothel case in Bleecker Street, which has a hermaphrodite, a man and a woman performing very explicit, I mean, lots of sex acts. And people's carriages are driving up. This was a popular slumming thing, to go to Bleecker Street and watch the sex shows for rich people coming from uptown. This is what 1915 culture is like. But one of the things that really fascinated me is that the judge, even though in that case, and typically homosexuals were treated horribly, you know, 10 years at hard labor and a $10,000 fine, and you never get out of jail unless you pay the fine, which they could never pay the fine, that kind of thing. But in this case, the judge actually said that the hermaphrodite was brought in on the wrong charge. And he wanted that charge to be, you know, rewritten. Because the person was, you know, like at that, the judge in that, by 1905-ish, is insisting that things be done in a correct way and that people be prosecuted for the very specific crimes they're accused of committing. And you see that in that span of time, and this is a larger story, there's been legal histories about the reform of the New York City courts and, you know, the American legal system in general, that it's much more professional. And it's part of the progressive era that you have all this institution building, the American Bar Association and the building of law schools. And this is a period of time in which a lot of changes are happening that make that possible, that make Comstockery seem ludicrous and un-American. That's part of what happens, because he is, in many ways, abrogates so many expectations that people have of how the justice system is supposed to work.
Is there anybody in DC who has a question, a comment? Then Lee?
So this is another question that is a product of the failure of my
Oh.
because of these case books that don't have what I said. One, just based on ignorance, one difference I see between the case law that grew up some years later surrounding political speech and the lack of it surrounding this is that lawyers were obviously making First Amendment arguments in the political speech cases. Were they making First Amendment arguments in these cases?
I never found a specific reference to the First Amendment. And again, as Jeffrey Stone pointed out to me, the First Amendment didn't apply to all these state cases. So the, and that's really interesting too.
It would have applied to the postal.
Yeah, they would have applied. They would have applied to the postal laws. And I can't speak to all of the postal cases because I'll tell you what I did with the postal cases, and this is a great dissertation topic or
Law review article,
LLD thesis topic, if that's such a thing. Because what I did was I took the arrest records and I took out all the cases with visual culture, and then I found those postal inspector reports and newspaper reports, and if I could, Theodore Schroeder's archives, by the way, which are in Madison, Wisconsin, he had a lot of case files, and I believe there are people I didn't write about who would fall into that category, and I can't answer your question because I didn't track down all that case law. But I'm thinking about like Lois Waisbrooker. I mean, a lot of those defendants, they're not all abortionists or birth control providers. I think some of them probably did cross the line into political speech, and you'd really have to do some deep digging to find out if anyone discussed them. In the context of obscenity cases involving sexually themed materials, I didn't find anyone who was using the specific language of the First Amendment in defense.
Ron?
So a couple of things. Before Holmes had penned anything in 1919, Theodore Schroeder had written 7 books, 7 books on free speech. A lot of those were common law arguments. I believe, correct me if I'm wrong, some of them would have been due process arguments under the state constitutions and also the federal. So the free speech argument was there. I mean, even early political speech cases came up in the context of due process. So the free speech argument was there. It might have been common law, it might have been due process, it might have been state constitutions, it might have been an interpretation of the applicable statute. But it clearly was there, this vision of what free speech should be. And Bob had mentioned David Raban's book, which does mention things like this. But you know, the other thing is we don't really have any idea of the lawyers who were involved in these cases. I mean, for example, someone like Theodore Schroeder, among others, you know, is virtually a person that's nobody even knows it. I mean, you could talk to professors who taught First Amendment law for years, and they never heard of him. So there's so much of this that's not on our radar screen. But anyway, in response to Lee's question, Lee, there were free speech arguments out there. Remember, the First Amendment was still, you know, a child, if you will, waiting to be born.
The free speech articles were being made. And if you go back to some of the early postal cases, United States versus Bennett, D.M. Bennett was one of the people that, one of the freethinkers that Comstock went after every bit as much as he did Ezra Heywood, who wrote Cupid's Yokes. And he was one of the first test cases, and the first time that the courts adopted essentially the Hicklin Test from England and applied it here in the United States. And so essentially ratifying this notion that anything that could create impure thoughts, and even if it's a single passage, that's enough, which was the law in the United States from 1879 when Bennett was decided until 1957 when Roth finally got rid of the Hicklin rule.
And there was a 1907 case out of Washington State that Holmes wrote. It was a due process case involving speech and free thinkers and what
Yeah,
have you.
all the state cases were pre-incorporation doctrine.
Right.
So they didn't rely on First Amendment. There were some federal cases that did.
But I did want to point out, I write about a case that I, to my knowledge, has never been on anybody's radar before, even though some of you may be familiar with Napoleon and Otto Cerrone, the photographers, who managed to get copyright protection for photographs on the basis that it was artistic expression. Well, they're back in court 6 months later in an obscenity case, defending a one-armed pornography dealer named Charles Conroy, who was the person who had sliced Comstock's face open with a knife in one of his early arrests. This guy had been a basement pornography producer in the Lower East Side. Comstock arrested him 4 different times over the course of many years. But in 1886, these photographers paid for the National Defense Association attorney Edward Chamberlain, talking about great heroes of free speech who are really not on anybody's radar. This guy shows up in court with like every major New York City photographer and produces a pamphlet, hands to the judge a pamphlet, Edward Chamberlain, titled Something to Read, which contained extracts from the sayings and writings of great men, including Henry Ward Beecher, Thomas Jefferson, and many others concerning what might and might not be considered immoral and what ought to be permitted and what ought to be suppressed. I never really found that exact pamphlet. I found another publication by the National Defense Association. But again, like probably, you know, what did Jefferson write about, right? I mean, imagining what's in there, they're making a free speech case. And I'm actually just publishing another article on this case that's specifically about the reason they were, you know, paying good money and all these photographers who were in competition with each other were coming together to the defense of this pretty wretched defendant, was because if the photographs in question, these actress photographs of women in tights, were deemed to be obscene, as Comstock wanted, they were going to lose a lot of money. And so, and what value was there in your copyright protection if something was deemed to be obscene? You couldn't circulate it. So you could own if you own the copyright to something for which you were just liable, there's no value in it. It's actually like, you know, antimatter at that point, right? And so, again, I think that's an interesting idea to tease out in terms, you know, on the part of legal historians, that I didn't really find any discussion of that connection between copyright and obscenity.
Well, I think we are at the end of our time. Many, many thanks to Amy and these fabulous questions and comments. We now have ideas for many projects moving forward. Thank you all so much.
Bye.